So I think I can start. My name is Thomas Hören. I'm the organizer of this program, LDE. I don't have any Wackelkontakt, Mr. Gruben, but I'm here in a hotel in Florence. It looks like if I were in Münster, but I'm in Florence at the University Institute in Fiesole. But the hotel has a rather unstable connection to the internet. So if I'm away, lost in the world of the things in a hotel, I will come back within 2 minutes. So don't take care for my internet connection. Second remark. We started in storing all our content at Spotify. I will send the dates on Spotify at the end of the week, so you can hear me at jogging in Hamburg or as a podcast. So what do I do now? I will talk about copyright law. Some people of you might think copyright law. I've done copyright law since thousands of years. I'm a real expert in copyright law. Why does he talk about copyright law? Because copyright law is one of the major exemptions to freedom of information. As I explained to you last week, I organized this course according to structure. There's an overall principle of freedom of information, and some regimes, some ideas from intellectual property rights are an exemption to freedom of information. They are taking freedom of information away by establishing property rights in information. We have discussed about trade secrets, and now we're talking about copyright law, because copyright law is the main regime for giving a kind of property right in information. Next week, Guido Westkamp will then explain in detail what this means, copyright law in the digital area. But now I want to give you a survey on general principles of copyright law. Of course, again, I have slides. I hate PowerPoint, but I can't avoid to give you slides. So here are my slides. I'm only giving an introduction. It's not a course for advanced experts. I give you an introduction within 90 minutes in copyright law. So, what is it? We have various regimes in intellectual property law. We have the protection of science by trademark. We have protection of invention by patent. We have the protection of design through design patent law. And we have protection of creativity through copyright law. And German and Austrian laws know if nothing helps, you can even use unfair competition laws as supplementary protection system. To explain what is not copyright law, I use two different cases. Of course, nobody of you, and that's good that it is like that, does know what witch's cheese is. A Hexenkäse. It's a very stinking cheese produced 40 kilometers from Münster in the Netherlands. And there was one producer who said, I'm so proud that my cheese is smelling terribly that I wish to say that should be protected by copyright law. He even went to the ECJ, the European Court of Justice, and asked, of course, the European Court of Justice said, if it only has to do with smelling is not a problem of copyright law. Copyright law has to do with brains. with creativity in brain. It should attract the brain, not the nose. Vorsprung durch Technik is a very nice wording of Audi. They use this sentence, Vorsprung durch Technik, everywhere in advertisement. The ECJ ruled that this is not a matter for copyright law, because a simple sentence like Vorsprung durch Technik cannot be protected by copyright law, but it's a problem of trademark law, because this sentence is so known as an advertisement tool that it can be registered in the trademark register. Here you see another sheet. I'm very proud for that because I've done it myself. You see, copyright law has to do with literary, scientific, artistic works, so-called intellectual works or creations, while patent law has to do with the symbols for technical invention. It's only for technical matters. So, and trademark law has to do with science, either registered or being known in the commercial world. And there are some small regimes like utility models that are small patent systems, or even design law is important. For design law looks a little bit like copyright law, but it's only possible to be protected in asking the trademark office for help. There's also sheet explaining that copyright law, I use the sections in German law. Copyright law only protects personal intellectual creation. That's important. There's no formal act. You don't need to pay, you don't need to register, whatever. That makes copyright law so attractive. Patent law, of course, is for technical inventions. Then is a registration and check required by the patent office, and that even published. Trademarks and distinguishing signs, either registered or known in the commercial world. Let us talk more on copyright law. And a German law professor always starts with history. Hope he doesn't talk while I'm talking. So the history of copyright law starts in Greece and Rome, because what they have was nothing. There was nothing in the Roman law, for instance, on copyright law. If you take Middle Ages, there was nothing except book curses. There was a sentence in the end of books saying, if you copy that book, you shall live with the devil, so you're going to hell. That's the first way of trying to enforce copyright law, but not very effective. The whole story starts with copyright law, with Gutenberg and the invention of books being printed. They were printed in Florence and Venice first. And of course, in the moment where you print a book, there's somebody making a copy without asking the right holder. Therefore, in Florence and Venice, this nice term, I have to show you where I am, should be a very, you would like to be here because it's the sun is warm. In Germany, it's raining like shit. So in Florence, this nice term, the legal regime invented a kind of territoriality principle of privileges. They grant a privilege for each sole printer in Florence and Venice, limited to the city-state. So it was only a regional privilege for a sole printer. What my researcher at the RTM once checked, she traveled to Florence and had a look to all these privileges, and she found no author's privilege. It was only for printers. So, and this story is important because it's the beginning of a very important principle in copyright law, but as well in patent and trademark law, the principle of territoriality. So copyright law is only valid based on a certain territory. So if you want to know when can I apply German law to a case, you have to look, do you use the copyrighted material in the state? So it's based on a certain territory. It's not a worldwide principle. So you have to look for the territory where this is applied. And then a very remarkably ugly lady came, Queen Anne of England. She was not only ugly as her face, but she was fighting against all the British printers. She was all the British printers hate this lady. So what do you do if you miss the contact to the printers? You give them a gift. And she invented the first copyright law of the world from 1709, the Queen Anne Statute. That was not only a privilege for a sole named printer, but it was a general privilege for all British printers. So, and that was the beginning of two words in the international copyright law. You should know these two words because even today, these two words are fighting against each other. They are clashing and had a lot of problems. That's my favorite sheet. I call it the New Europe against Old Europe problem. New Europe was a case, a term used by George Bush, who said there are countries in Europe which are new, United States and even especially important United Kingdom, and there's this shitty old Europe, France, Germany, Spain, Italy. If you have a look at Great Britain and the United States, they start their story at 1709, Miss Queen Anne Statute. It was a protection of printers. In the modern term, you would say a protection of investors. So it was not a protection of authors who are writing stuff, but a protection of the person who is giving investment to a work. There's a very famous principle in British law, the sweat on the eyebrow principle. They say if an investor is sweating, is a sweat on the eyebrow. So if you feel there is some heat, that is a reason for giving copyright law. This principle of copyright law in England is a problem of money. Investors want to have money, 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 money. And the rights in copyright law are transferable to other investors, so it can be easily transferred to and from. It's also possible that the investor is a legal entity, so even a legal entity can claim I am the copyright owner. Coming back to old Europe, that started in 1789. Last year, I was a professor involved in a state exam for legal students, and I asked the students, what happened in 1789? There were 5 students sitting there, and they looked like, oh, what happened in 1789? And then finally, one guy raised his hand and said, I know it. It was the beginning of the First World War. I said, wow, that's incredible, incredible, First World War. Now, it was the beginning of the French Revolution. This was a famous declaration of human rights in the French Revolution. They invented real copyright. They call it even better, droit d'auteur in French. So it was a protection of authors, not of investors. Authors, they need to be original. And it should be as original as Rimbaud, Verlaine, Rabelais, Charles Dickens, and whatever. But you should be really have a high level of originality. Those are very high requirements compared even to the English standard of sweat on the eyebrow. It's not enough to have sweat on the eyebrow. It's necessary to be really creative. What does a French author wants to get from copywriter? He wants to get laughed. He wants to be seen. He wants to be recognized. That is what he wants. Of course, if he gets €2 for a bottle of red wine, that's okay. But the most important point is love. We call it droit moral. So the moral aspects are more important than money aspects. I don't know what you think about love. Is love transferable? Of course not. Therefore, it's non-transferable. You can give it away. It is not for legal entities. You can say a GmbH in Germany has love rights. So, of course, these two systems are still clashing together since 200 years. So we need to have bilateral treaties and international treaties to harmonize a little bit the world between old Europe and new Europe. That has been done by the Berne Convention. Revised Berne Convention, RBC, is still valid today as the first international copyright treaty from 1883. Unfortunately, in Berne, when they made this convention, only old Europe countries were present. So that's a convention with sticking to the principles of old Europe without United States and Britain. The British people and the United States were only in Paris in 1952, but with the Universal Copyright Convention, that was really the first treaty including the United States, New Europe, and United States. The things get very, very bad, not only due to Trump dump, but already in the times of Bush, because Bush had the feeling the UNESCO is so bad and we should retire from UN organizations. So he skipped his first predecessor, Ronald Reagan, skipped the participation in the UNESCO, which was responsible for the Universal Copyright Convention. And the US adhered to the WTO. So there are still today, apart from WTO, and WTO created a new international treaty, not only on copyright law, but as well on patent law and trademark law. It's called TRIPS, Trade-Related Aspects of Intellectual Property Rights. So that's a famous TRIPS agreement. So I don't want to talk too much and too long about that. So what happens in Europe? We made one mistake. In 1989, we allowed the British to become a member of the EU. So we had a clash of British and continental Europe in copyright law. So the Commission has to plan a new way of harmonizing international copyright law. They made several directives. I will talk about the directives in 2 weeks. Software protection, database protection, and especially the copyright directive. I can talk to you and ask you, what do you think about software protection as part of copyright law? When you've listened to me, do people who like to make programs, who are working as a programmer, are sweating or are more original in the sense of creative? So they are sweating like hell. They have sweat on their eyebrow, but they are not original compared to Berne or Rimbaud. So, but for the software protection directive, we learn that was a victory of New Europe. The British managed to integrate in copyright law their understanding of software protection based on sweat on the eyebrow. So let us start in having a look on the subject of protection. You can ask yourself very easy questions, the so-called W questions. What is protected? Who is protected? How he is protected? When is he not protected? That's all. So to summarize that, what, who, how, and when not. So we are talking now in the second section on how, what is protected. I'm not only talking now about German law. I try to be as international as possible in order to define when is a work really original. So is a part of this copyright work model. You have to distinguish two stages. On the first level, you're asking yourselves, what form can be the basis for creativity? Because we have one very important thing to understand. Ideas are not protected. So that is again a reference to last week. Information wants to be free. So ideas cannot be protected. Ideas doesn't belong to anybody. Ideas are free. And that's a part of the system not only in copyright law, but also in patent law or unfair competition. Freedom of ideas. That's a very bad news for some industries in Europe, especially for the advertising industry. Imagine you are creative in the sense that you are planning an advertisement campaign for a company. All your nice ideas, how you do promote this company in advertisement, are not protected. So you may remember last week I explained to you there's one tool which you can use for the protection of ideas, especially in the advertising industry, that is trade secret. So try to draft an LOI, a letter of intent, in order to help the customer that he is not losing all the rights in his ideas. The freedom of ideas includes other matters like the implementation in a concept is not protected. Algorithm, the basic mathematical rules underlying a software product. That is mathematics, that's the idea. It cannot be protected. The ECJ decided in the famous SAS case, software languages can also not protected because they are part of the freedom of the ideas. Interfaces, they cannot be protected according to the ECJ because of antitrust questions. Nobody wants to make Microsoft so powerful that they can use copyright law for fighting against third parties due to the use of interfaces. And there's one famous test, the dictated by necessity test. Let me explain you that test by using a case which I've decided as a former Court of Appeal judge. I had a case in Düsseldorf where 5 nerds were coming and saying, we have created a very nice software, a railway system software. And we are fighting against Ubisoft because they have not copied the internal side of the software, but the way how the software looks like when you use it. Because we created railway stations, we created trees standing in front of the railway station, and that can also be found in the other program of Ubisoft. I said to them, if your matters in the surface of your program is this dictated by necessities, you are not protected. And to create a railway program, you need to have trains, you need to have railway stations, you have to have trees in front of a railway station. That is all dictated by necessities. And everything dictated by necessities cannot be protected. Oh, this is a nice sheet. I can explain you. Now, I wonder whether you have studied philosophy. There's a famous guy called Platon who had the idea that there are existing ideas as such. And there was his opponent was a famous guy called Aristoteles. And he said Platon is a liar because he called it hylomorphismus. A form is always combined to an idea. There doesn't exist an idea as such. You have always a link between form and idea. That Aristotelic view is important in copyright law because how can you define the pure idea distinguished from a certain form? For instance, in the famous case of Dr. Chivago, the German Supreme Court said, you cannot distinguish between the internal story and the plot and the appearance of the book. So the Supreme Court said, if you're writing a book, there are special rules for fables. You distinguish between an external form and an internal form. So if you are copying the figures from Dr. Chivago, a famous novel, then you get liable for copyright infringement. So at most, the most important protection is done by confidentiality agreements with contractual penalties. So if you have only ideas, please think of drafting an LOE. That was the first level. Now we're coming to a second level. If you have found a certain form, you need to find your personal intellectual creation. So, personal intellectual creation. So a rather big problem is, for instance, the problem of personal. What is a person if you have AI? Can an AI system create works in the sense of copyright law? We'll discuss that in 2 weeks. So what does personal mean? Does it mean only a human person? Or can we extend that to an AI system? Intellectual, the witches, these Hexenkäse cannot be found protected by copyright law because it's only a question of smelling. That's intellectual means it should be important for the brain, not for the nose. And then creation. And there we have a problem with Germany, Austria, and with Italy. Because there, in these countries, they distinguish in order to determine creativity between fine art and applied art. Because they said in the fine art world, we use the same famous principle of small coin. Small coin, kleine Münze, means if you have to do with fine art, it can be presumed that this is a creation. If you have applied art, that is always a thing which justice hate. Which, if you have to do with design, it needs to be well above average in order to get a protection by copyright law. So you see here that has been done by the BGH, the famous Supreme Court in Germany. You find it in Italy, in Austria, but you see there are some remarks of the ECJ, and there's especially one ruling. There is a famous Brompton case. In the Brompton case, decided by the ECJ, the court integrated some new standard of originality. He doesn't claim to test the high above average or small coin. He said the work should demonstrate intellectual creations in the sense that a person shows his personal view of certain things. In this moment, the judges of the ECJ are determining, for instance, the famous USM Haller case. Do you know USM Haller? You all have USM Haller as an advocate in your office. Very nice furniture. I don't have it here in the old hotel. Can USM Haller be said to be only a kind of a problem of applied arts? So is a well above average test? Or do we have to abolish this two-level test of asking fine arts or applied arts? The state attorney at the ECJ has already delivered his opinion on the case, and he has said, throughout Europe, we should leave this two-parts model in determining beautiful versus applied art away. We should skip that definitely. But what does the ECJ said will say at the end? We don't know. There's no date for a decision fixed. Until now, we are all waiting for this decision. In several countries like Italy, Denmark, Germany, Austria, we have special rules for photographs and films because When legislators said that is so crazy what these guys are doing. They are making photographs by making clicking and waiting once a minute to get a bird fly in front of a camera. That is copyrightable, although it is not a copyrightable work. So there's a special protection for every photograph and every film. They are protected apart from copyright rules. So, Section 3. I said, what is protected? Who is protected? This is the second question. So, who is the author of a work? That's very important because we have three types of authors. The main idea of copyright acts is always the author is himself alone, but it may be the case that the author is a joint author creating works together with other authors, for instance, in such a way that the contribution cannot be exploited separately. That is very important in the digital world because joint authorship happens quite often in the digital world. Take, for instance, Linux. Linux, you have 3,000 programmers who are working together for one single program. And if you have such a case, let me say it. If you have a joint authorship, you have to ask every co-author for his consent if you want to exploit a work. That causes a lot of problems, for instance, in distributing Linux, open source. If you have an author in employment and service relationship cases, so an employed author will not give his rights away automatically to the employer. That's different from the United States and different from Britain. There you can say, we are making a work made for hire. If you say that word, work made for hire in Great Britain and US, you are automatically regarded as the author in the sense of copyright law. No, but in France or Germany, an employee remains the sole author of the work. So copyright is not transferable. Then you see again principle from 1789. But is it possible to make contractual grant of drei use to the employer? But this granting is not automatically the case. So you have to ask for that. Next question. What is protected? How he is protected? Who is protected? And now the question, how is a author protected under copyright law? Here again, you see the two worlds. The world we are living in is old Europe, 1789, with droit moral, that's a very bad translation, moral rights. It doesn't have to do with moral rights. That's the side where the love relation of an author to his work is mainly protected. And of course, on the right side, you see coins, money rights. So the moral rights have to be distinguished from exploitation rights. Let us go first to have the moral rights, droit moral. So these are the three most important rights: the right of publication, the right of recognition of authorship, and distortion to the work. Let me use the first right. The author is the only person to decide whether and how his work will be published. He is the one who is deciding on the attribution of his work. He has a right to be named as the author, and he can prohibit distortion. It's very complicated to decide whether a certain use of a work is a distortion. Would you regard that use of Edvard Munch, for instance, Cream, on the right side for a book as a distortion? Of course it is. And we have a lot of problems with distortions in the area of architectural work. That was a famous case of Berlin, the central station. So the Deutsche Bahn decided to cut away the first class hall in order to have a small railway station. The architect who has planned the central station said, "This is a violation of my moral rights. I had a second class hall and a first class hall. Now the first class people are standing in the rain when they enter Berlin." And he won, of course, the case. You're not allowed, as Deutsche Bahn say, I think this plan is ugly and we don't need it anymore. In every state in Europe, we find moral rights in several other places. So we find traces in certain other parts of the copyright law. It's not only a question of these three rights. So, money rights. Copyright grants comprehensive economic rights to the work. The author receives the right positively to use the work and negatively to prohibit the use by third parties. In Germany, for instance, only an example, we have the full physical exploitation and the intangible exploitation divided from that. We have an exclusive right of reproduction, distribution, exhibition, and apart from that, the right, for instance, in 39A, of making available to the public. What is complicated is already the right of reproduction, because in the digital world, reproduction, of course, is scanning, copying, uploading, downloading the full copy. What is a temporal copy of the random access memory, of the working memory? Is that a reproduction in the sense of a copyright law? Second right, very complicated, distribution. It has to do with a physical copy that's sold to other persons. There's a right of distributing physical copies via sale, rental, lending. There's complicated because in the internet world, we don't have physical copies. Does there exist a distribution right in the internet? Nobody knows. That will be a topic of Guido Westkamp next week. So, and another big problem in the digital world is the public access right, for instance, making available to the public. That right has been given, newly integrated in all member states of Europe, to say internet use is a kind of special right granted for the author. The problem is that making available to the public rights includes public. What is public? Is, for instance, intranet. Is it public? Small networks. What is the borderline between public or non-public? So, I need to talk on other rights. We not only have the author of works being protected by copyright law, but we have other people getting ancillary rights. For instance, most important is here the protection of performing artists. Performing artists like Uschi Glas or Julia Roberts, the very bad artists, they are not creative, but nevertheless, the people go to cinemas to see Uschi Glas or Julia Roberts. Therefore, they get some kind of second-class rights as performing artists. Or film producers, the same problem. Film producers only give money for films. In Britain, of course, they are the main heroes. They are the authors. But in old Europe, we think film producers are not creators at all, for giving money is not a really creative work. But they get an additional right, second class, as film producers. So, our third example, sound recording producers like Sony, these big companies, it is impossible to say that they are creators, that they are authors, because they are not natural persons, they are big companies, so they get ancillary second-class right under the protection of sound recording producers. Let me mention one very important case with existing. Perhaps you've heard about Moses Pelham and Kraftwerk. Kraftwerk was a very nice group of composers who made electric music, and they were taken by Moses Pelham and Sabrina Settler for hip-hop cases. So there are certain pieces of hip-hop music where you can listen for 2 seconds to Kraftwerk. Is it a violation of the sound recording producer right? That was a very famous case because it's not finished. It was decided by the Federal Court of Justice, then by the Federal Constitution Court, then by the ECJ, going back to the Federal Court of Justice, going back to the Court of Appeal of Hamburg. So it's still under decision today. So now the final question in copyright law, when not, there are cases where you don't need the copyright holder to give their consent for a certain use of works. And you remember me, I've said, when you extend the borderlines of a certain legal regime in information law, you should also extend the limits of this system so that the IPR rights are not too overemphasized. So there should be clear balance of new extended property rights versus freedom of information. And that's done by five models. There's a very famous checklist which I've invented. It says you can find 5 ways to restrict the overpower of rights holders. Statutory licensing means you find in the copyright statute a provision and that you don't need to pay if you won't do anything with the work. The second strategy, collective licensing, you go into a collecting society. It has nothing to do with helping the poor people. That is an organization of right holders and ask them for the permission to use the work. Famous collecting societies, for instance, the GEMA, very powerful in Germany. I will come to that in a minute. Single licensing is the worst solution. You're saying, I need to have a contract with each right holder, including authors, including second-class workers, who have to integrate all of these people in one contractual model for giving you the rights. Technical licensing means the easiest way to protect works is to protect them technically against hackers. Is that allowed or not? What is restricted? We'll talk about that. And final solution, no licensing. The same. I don't have any sense for taking these rights seriously. I want to do what I want. One day I had a friend, Oliver, who said, I want to build up illegal service on copying every material in the internet. Thomas, please tell me, where do I have to go to find a good place where I can live the world of no licensing? Let me ask you, can you imagine a country in the world where you can do whatever you want? This country is part of Europe. I don't want to recommend Zimbabwe or whatever. The person who is giving me the right answer gets a bottle of red wine. I need to find a country in Europe which is not bound by international copyright treaties, not part of the EU, and you can build up any company which you want. This country is only bound mostly by Roman law. Try it. Don't be shy. So I need to see what you answer. Two as Kosovo is not a real country. Yeah, Vatican State, that's always happening. If I'm saying Roman law, people think, oh, it's Vatican state. But Vatican is a part of Italy when it comes to copyright law. Monaco is whatever it is part of France. Well, Bulgaria is part of the EU. It's a tiny, small country. Switzerland is really small, but they are powerful. I don't want to say Andorra is too small. There is one country which is still sticking to Rome law in the middle of Europe, and nobody is taking care. Yeah, Engelmann. Engelmann is a winner, and Peterson. but Engelmann was the first. Mr. Engelmann, or Miss Engelmann, send me your dates, the address, and I will send you a bottle of good red wine. So it was San Marino, and my friend said, so, okay, I go to San Marino, I trust you, Thomas. And they told me one day there was a knock on the door in San Marino, and there was the state president of San Marino at his door and said, Oliver, do you want to see all the posts of German courts? Yeah, oh, yes, he said, I want to see it. I had a huge washing tub full of posts. And I said, Oliver, it's quite cold here in the house. Can you open the fire? And they were throwing all the letters in the fire. And that's how my friend Oliver lived for 7, 8 years in peace and harmony and wealth. Very nice example of no licensing. And so, statutory licensing. What is happening with statutes with exemptions? Perhaps you remember me. Last week, I've explained you 3 different models of interpreting these exceptions. The orthodox way is copyright is so powerful, it has been interpreted quite broadly. So restrictions are only exceptions and need to be interpreted narrowly. That's for me the total wrong way. Although it's done in Munich, in Hamburg, Bayreuth, whatever, they are still doing it. The other guys are US colleagues or Amsterdam colleagues who are believing in the sentence copyright should be interpreted narrowly as we have the fundamental principle of freedom of information, and therefore restrictions are not exceptions but exemptions, and they should be interpreted broadly. As constitution lawyers, that's me. I'm still 2 years in Münster. So I say restrictions shall be interpreted narrowly or broadly in the light of the Constitution. What kind of limitations are there existing? The first is copyright law elapses after 70 years of the death of the author. So after 7 years, PMA, post-mortem auctors, copyright law exists and not anymore. Therefore, I hate the word geistiges Eigentum, by the way. That's the most stupid wording of the Orthodox people, because Eigentum, property, does not elapse at all. So you won't say intangible property elapses after 70 years of the death of the author, but copyright law is limited to this 70 years protection. Then we have another limitation. There's a principle of exhaustion, that has nothing to do with your personal situation now. There's a principle called in the United States first sale doctrine. When you sell a tangible copy in Europe, this copy is free to circulate. You cannot control the further circulation of that copy. Does it apply, for instance, to software? There was a famous case, a very remarkable case of the ECJ, where the ECJ said that's also applicable to software. If somebody is buying a software in Bulgaria, mention that, or Romania or Monaco, and is selling the copy again in Germany. That's free. Microsoft cannot control the further distribution of these copies in Europe. That's only applicable in the EU, but then it's also applicable to software, even if you download the software and buy it on the internet. Astonishingly, the ECJ said in the case from Netherlands, it's not applicable for ebooks. So you can download for your Kindle a nice book, but you're not allowed to resell the book to another person. I don't know why, but that's a fact. So, another limitation, official works. When you want to use official works like court decisions, statutes, that's free. That does not apply to technical standard norms, but there are more and more decisions like the US Court of Appeal who said the non-commercial distribution of technical standards is free and can be used as part of fair use. That's the same approach used by the ECJ several months ago. European harmonized technical standards cannot be governed by copyright law. So, talk about that. Freedom to make private copy, a very, very important limitation. You have a right to make copies for personal purposes, private purposes. That's free, but you are paying for that. Freedom does not mean here that this is not being paid. When you may buy a computer or a scanner or a CD, there's a certain percentage of money given to a collecting society for having this freedom to make private copies. Then, very important is a part of the EU directive, so every member state of the EU has it, the freedom to make temporary acts of reproduction. That is a problem which I mentioned before. Does reproduction include temporary acts, the use of reproductions in the working memory of a computer? If that would be the case, the big companies have the right to control even the copies, temporary copies on the internet. That has been expressly excluded in all European member states. Most important is, and which have no independent economic significance. Because temporary copies can not be independently being sold to other people, you can make them. So, can we go further? I jump to the citation freedom of quote, very important limitation again. Everything can be used, not only 7 notes of music, but it's necessary for the freedom of quotation to substantiate one's own statement. That must be the purpose of quoting. You have to use a quote for justifying your own statement. This is pastiche. I think Guido Weskam will, of course, mention the freedom of pastiche in his lecture next week. That's a new limitation foreseen by the European Commission in a directive. Nobody knows what is pastiche, but there's a feeling that there's a separate freedom to use musical parts in order to combine it with other musical notes and to build up a new piece of music. Is that, for instance, the solution in the case Kraftwerk against Sabrina Settler? That is the consideration of the Court of Appeal of Hamburg, second case. But that is a favorite topic of Guido Mesker. Parody has a new definition. What is parody? In the past, we have mentioned that Germans are not funny. So if you are trying to build up a parody by making funny remarks, it has been forbidden by the Supreme Court in Germany. But now, as we have a European term, parody, this European term includes fun. Parody requires humor and mockery. So if you're only criticizing a work, then it's not parody. So I don't want to make too much. I can tell you hours of that. Collective licensing, next strategy. That is all for statutory licensing. Now we're talking about collecting societies. The idea is one-stop shop. That means you're going to one special trust shop, and there you get all the rights which you need for entering the internet, making music virtually. This one-stop shop is normally done in Germany by GEMA, the famous big collecting society for music composers. We have others like Vogel Ward, Vogel Bildkunst. Every state has its own structure for collecting societies. Here's a slide combining these different collecting society. The most dangerous collecting society, because it's so powerful, is GEMA. I'm not allowed to say anymore GEMA is similar like the mafia. That has been prohibited by the GEMA in a famous court case in front of the District Court of Munich. So I send my apologies to GEMA. Of course, GEMA and mafia are totally different. GEMA is working from Munich, mafia is working from southern Italy. So that is one of the reasons why I shouldn't say that. There are special acts for administering this collecting society in Austria, in France, in Spain, or in Germany. In Germany, it's done by the Collecting Societies Act. And most important is that sheet. There is a special idea that collecting societies have an obligation to grant rights and have an obligation to let anyone enter who is part of their business. So normally we have the freedom of contracts in civil law, but here we have rare exceptions, so that the GEMA also obliged to let anyone enter the GEMA who is a music composer, and they are under obligation to grant rights to every music user. Okay, second one, nine. Single licensing. How do we draft a digital contract in the internet if it has to do with copyright law? This is again a very important slide, because I have the feeling every contract has always the same structure. It doesn't matter whether it's a copyright contract or you are drafting a marriage contract. Every contract has always 6 parts, not 7, not 5, just 6. One is preamble, main obligations, and secondary obligations, performance disruptions, termination, and miscellaneous. The preamble is the most important part because the preamble is a main directory for interpreting any obligations under the contract. Therefore, you should be very careful if you draft a preamble. And we have one specialty in Germany. As a specialty, we have to say in the preamble what is the legal nature of the contract. Why is that? Because we have the section in contract law in the BGB, section 307, says that even in B2B contracts, you are not allowed to draft a standard term which makes a variation of the legal nature. You cannot put the legal nature away and draft the contract as you want. You have to stick to the legal nature of the contract. So, initial is very important. Only the creator is the author, the employee, the person, the investor is nothing. So what you should do is this matter. You can not draft a translative transfer of rights. That's impossible in copyright law. You can ask for an exclusive right of use or a single right of use. That's the two chances. If you want to be the only person who has the right to use a work, draft exclusive. If there are other people who has the same right, simple rights of use. So when you use the structure, don't speak about license. If somebody in my institute is speaking about license, he has to pay €5 in a saving box, in a briefcase, because we hate license. The term license doesn't exist at all in copyright law. Speak about a purchase or lease of rights. That's okay in the preamble. And then define whether you want to get granted an exclusive or simple rights of use. And the very famous sentence then means, I want to get an exclusive, transferable right to use the work as mentioned in the preamble. Exclusive, transferable, that's all. Exclusive, transferable, that's all. Exclusive, transferable, that's all. Exclusive, transferable, that's all. You will always remember this crazy professor who told you 5 times that you should have exclusive, transferable, right? That's what I get. So it's okay. The problem in Europe, of course, is existing since 3 years. We have the main principle of iudex non calculat. So the price for a right cannot be calculated. But we have a directive, the so-called Infosoc directive, that says that every member state have to integrate the principle of reasonable remuneration, so the right holder has the right to get a reasonable and fair remuneration, and if you're paying less, you get sued. That's the famous DSM directive. So, false, that's all miscellaneous I want to speak about it. Next way of getting rights or not giving rights away is technical licensing. And then you say, I will stop all these hackers and nerds from using digital rights. That's a famous word of code as code. So the big companies are beginning to store their content in a way combined with code that this content can only be used for that and that purposes. This is a principle called code as code, according to a famous book of Lawrence Lessig, professor in Harvard. So we call it digital rights management. An example, of course, is CSS that prevents DVDs from being copied. There are provisions for that in every member state, where it says if you are circumventing these technical measures, you can be sued for damages. There's some criticism how limitations can be protected against overprotecting DRMs. And the final strategy is no licensing. It simply says no. It says how much does copyright infringement cost? Unfortunately, infringement costs a lot due to the fact that I have here now a new slide with German words. It's simply saying there are several rights which are a catastrophe for users. You have to ask yourself, does copyright exist? Then second test is there infringement? Is the use covered by limitation or license, and then it's infringement. So it can be very, very expensive due to the damages. There are three ways to determine damage. You can take the profit away from the infringer. You can ask for a real compensation according to your calculation, or you can ask as a minimum what should an infringer have to be paid. So that's rather dangerous. I wouldn't recommend that on the long run. So this is the idea of triple damage calculation, specific damages, surrender of the infringer's profit, and license analogy. There are three ways how damage can be calculated. So, yeah, I think that's the last section, international copyright law. Normally, as a matter of fact, we don't have a case for involving only nationals in copyright cases. No, the normal situation in the digital world is, of course, there's an infringer coming from Turkey, there's an infringed person coming from France, there's a case which wants to be settled in Denmark, and there's a publishing house in UK. So all parties are from different countries. What is happening then? We have to solve the issue of international civil procedure law. Where can I sue somebody who is living in Turkey, as regulated in this normal civil procedure law, or in the separate regulation of the European Commission, the so-called EuGGVO? Both regulations say the place of residence of the defendant is a relevant case, so we can sue at the residence of the defendant, or you can sue at the place of the offense, and that's the case where the action or the success of the offense can be seen. That is important for internet cases because to define the case, the place of success in the internet, if you are storing illegally content on a website, this website can be get access to in every European member state. So you can choose wherever you want to sue. You can choose as a place of success. If you have administered this problem of civil procedure law, you are not automatically in the Copyright Act, for instance, the German Copyright Act, but you then need to solve the issues of Ausländerrecht, of foreign lawyers, because every state has its own rules. What do we do in copyright law with foreign works? For instance, Section 120 in Germany said every work made by a German is protected under German copyright law against violation. That applies as well to EU foreigners, but if you're coming from Turkey, you have a problem. Section 121 says foreigners only receive copyright protection in accordance with the content of international treaties. That is the reversed Berne Convention. So even if you have a Turkish author and he has managed to get a German case for his copyright question, the German court will not apply the Copyright Act, but the RBC. Fortunately, the RBC has a regulation saying that all people from foreign countries have a right to get equal treatment with nationals. And with that trick, you're within the Copyright Act. So the last case, which I want to mention only to see how complicated it is, perhaps you know the 3 question marks. Nobody apart from Germany and Austria knows the famous drei Fragezeichen. Famous children books. We had a case in Düsseldorf, which I decided. There was an author called Robert Arthur. He has written volume 1 to 7 of this children's series. After his death, daughter and son revoked the exploitation rights under US law and transferred them to Sony. That was the time when Sony stopped the 3 question marks, especially on the audio cassette form banned on the German market. First question will be, in that case, where can Sony sue, which is the relevant court for that case? You have to look in civil procedure law, in the ZPO, or in the European regulation on that topic. And they said you can sue where the defendant has his seat. That means Germany, it was a German publishing house. Or you can sue at the place where the market, relevant markets can be found. As again, so Germany, so you can sue in front of German courts. First question. Second question, foreign law. So the foreign law of the Copyright Act. Sony is a foreign company. They can only administer rights according to the RBC, but the reverse Berne Convention says they have a right to get the equal treatment as German right holders, so you are within the Copyright Act. So if you apply the Copyright Act, the third question comes to existence. Can we simply apply the copyright law, or here it says the children revoke the exploitation rights under US law. So US law is totally out of bounds. We use the content of the Copyright Act. In the Copyright Act, the first question is, Robert Arthur is the copyright owner, has been the copyright owner, and the only way a copyright owner can give and transfer his rights completely to another person is a testament, a testimony, testament. So we have to ask, what is the law of the succession? What does the German law of succession say? So this Robert Arthur has made a letter saying, in the moment I die, I will give my children $10. I hate them, but I give the rights to the University of Michigan. So all the rights are lying now in Michigan. Of course, they first had to look where is Germany on a map, but Sony has no rights got from the children, because the children are nothing. So you see, Sony has bought the rights from somebody who has no rights at all. A very, very bizarre case. So that finishes my quick survey. Very quick survey. It was only necessary for you to understand what is happening with Guido Wesker next week, because we will not explain you the structure of copyright law, but the real problems of digital rights in the copyright world. Do you have any question? Your own looks so stubborn. It's not necessary. You have made it. So I wish you good luck with new knowledge. At the end of the week, you get the details from for podcasting. See you all in good shape next week, Tuesday.
Thank you, Professor. Have a nice day.
Thank you. Bye.
Bye bye.
Thank you.
Thank you. Goodbye.
Thank you. Bye bye.
Bye.